All right, everyone, we're ready to start up with our last panel of the day, and that is processes for assessing validity and quality of claims in MDLs, class actions, and mass arbitrations. And our moderator is Judge Micaela Alvarez from the U.S. District Court for the Southern District of Texas.
Thank you very much. I have to make one correction as we start out, and that is that as of this month, I am now a senior judge in the Western District of Texas. I decided that I was moving and I'm going to be in San Antonio, so I will sit there for an indefinite period of time now that I'm a senior judge. But thank you very much for having us this afternoon. I know you're a captive audience, and I know the LEC is very good about saying, you have to be here for the whole thing. But I really think you're going to enjoy this panel because I think that throughout the day, from the various panels, we have heard reference to mass tort litigation, MDLs, and all of the issues that come up with that. And so today, this afternoon, we have a very distinguished panel that is going to touch on the process for handling those MDL cases, mass arbitration. We have some very distinguished speakers with us this afternoon. I'll do brief introductions. I do encourage you to read their bios because I think they're very impressive and they will give you a lot more information about our particular panel members. But I'll start with Kaspar Stoffelmayr. He is with Bartlit, Beck, and he does mass tort litigation, product liability litigation, class action, and he is one of the leading experts on product liability, having extensive experience in that regard. And next, and I'm working from my far right, obviously. Next, I have Michael McTeague. He also does class action as a defense attorney. Does a lot of work also in mass arbitration. And I think that is one area that we as judges probably don't really know a lot about what goes on in that process because when there are cases that go to arbitration, we send them off depending on our practice. We may dismiss them at that stage. We may keep them on our docket. But if they do come back to us, the issues that come back to us are very limited. So at some point in time, hopefully Mike is going to touch on sort of what goes on behind that door. And then we have right next to me, Archis Parasharami.
Parasharami.
Okay, there you go. Okay. Anyway, he does a lot of business litigation in class actions and complex litigation. And so you're going to hear from each one of these. And I will start out by asking each one of them to do their opening. And I'll start with Kaspar. He's going to focus a little bit more on the mass towards the MDL, and then we'll move down the line. So, Matt.
Thank you very much, and thank you very much for inviting me. On the topic of sort of assessing the validity and quality of claims, especially in mass torts, I want to start with sort of a focus on what may seem less relevant than it is, and that's the new federal rule of civil procedure 16.1. And I appreciate that obviously if you sit on a state court bench, the federal rules are, as persuasive as you want them to be. But I think there is a lot that happened in the development of Rule 16.1 and the motivations behind it that are relevant in any court. And I'll, at the end, talk about a couple specific points or specific reasons why I think this is actually becoming more and more important in state courts than it probably has been for many of you. So assuming not everyone follows the amendments to the federal rules of civil procedure super closely, Rule 16.1 is a new rule of federal civil procedure. It's a brand new rule, not an amendment to an old rule. It will become effective on December 1st of this year. And it is the first federal rule that specifically governs MDLs, so multi-district litigations. That MDLs capture lots of different kinds of cases. There can be, patent MDLs, antitrust MDLs, all sorts, as long as there are a sufficient number of related cases in different districts that the system thinks it makes sense to consolidate them somewhere nationally. What I'm going to talk about has to do with mass torts, and the federal system mass torts inevitably or close to inevitably end up in an MDL of some kind, and they'll get assigned to a single judge in one district for pretrial purposes. In theory, they are then remanded back to the court where they, so to speak, belong for an actual trial. This Rule 16.1 has been in the works, since 2017. I think were the first comments submitted to the Rules Committee asking for a rule of civil procedure to govern MDLs. And the while MDLs, like I said, are broader than just mass torts, a lot of what's behind Rule 16.1 really came out of lawyers and judges concerned about the way mass torts sort of progressed in federal MDLs. And I think there were really two big motivating concerns. One is that MDLs felt a little lawless to a lot of lawyers, and in the sense that the regular rules were sort of kind of half applied only if they really made sense. And part of that was inevitable because these cases are just different than other cases and require different kinds of case management tools. But part of that, at least arguably, some argued was not inevitable. Catherine gave the example earlier in the last panel that at the beginning of a big case, the judge might say to the lawyers, listen, I've never had a big MDL. You guys have done this before. Give me your suggestions. And as an advocate, that's terrific, as long as you're a good advocate and the judge adopts your suggestions rather than the other side's suggestions. It seems like a good system. As a citizen, it kind of drives me nuts because it feels like if you had a baseball game, right? At the beginning of the game, the umpire got the managers together and said, listen, you guys have played a lot more baseball than I have. How many innings do you think we need? And one guy says, well, the playoffs last year, turned out that 6 innings was pretty good. Another guy says, no, never more than 4. You never want more than 4 innings. That's kind of what it's like relying on adversaries to tell you what the science is. Now you're relying on adversaries to tell you what the rules of civil procedure should be. But in any event, that topic really got no traction with the Rules Committee. No one seemed bothered, as bothered at least as I personally felt, by the sort of loosey-goosey approach to the rules. The second big driver was the burden of what I'll just call unsupported claims. People use a lot of unvetted claims, unexamined claims, meritless claims. And what we're talking about is the phenomenon that in every big mass tort MDL, it seems to turn out that somewhere between 20% and 50% of the cases probably never should have been filed. That is, someone says, they have an injury, they have an injury due to taking a pharmaceutical, and it turns out that they never took the drug, or there's no evidence they ever took the drug. And if it's a prescribed pharmaceutical, if you took it, there are medical records, there are pharmacy records. Or it turns out they don't have the diagnosis. The case was about colon cancer. They have no medical record showing they've ever been diagnosed with any kind of cancer. So 20 to 50% of the cases seem to fall in that bucket. And that is, problematic for lots of reasons. And that topic did generate years of discussion that partially resulted in the new Rule 26.1. And again, I want to be clear because it sometimes leads to confusion that people say, well, who would file a meritless case? That's dumb. You're a bad lawyer, a bad business person if you file meritless cases. That is not what is going on. No one is sitting around saying, I wonder how many meritless cases I can file. That sounds like a good business decision. What they're doing is filing unexamined cases, cases that nobody has looked at. There are lots of reasons why that happens. But large volumes of cases get filed that no one has given any close look to. And the reasons how that happens, we can talk about if people are interested, but that's, plenty of time could be spent on that alone. They're unexamined. And if you don't look at the case, if cases come in through call centers, as they do, through lead generators, and you don't have an opportunity or an interest in looking at those cases carefully, some percentage of them are going to turn out to be nothing there. Some percentages will probably turn out to be good cases. The problem is you don't know when you file them, which are the good cases and which aren't. In the early discussions about this topic, there was a fair amount of skepticism, I think, in the Rules Committee and among judges, some judges, at least generally. Part of it was, well, who would file these cases? There were some sort of prominent academics who took the view, well, if I can't figure out why people are filing these cases, it's obviously not happening. That's a narrow way to see the world, that things only happen if you can figure out ahead of time why they happen. And there was also a view that, well, okay, but who cares? Is this really a big problem? Okay, the court is flooded with thousands of cases that no one has looked at, but in these big MDLs, the devotion of judicial resources is approximately the same if it's 1,000 cases or 10,000 cases. So there's a little bit of why should we care about this? And that changed over time. And I don't know why exactly. But I think part of it was historically, this is an old problem, but it's not that old a problem. There are things that changed in the market, so to speak, say roughly 2007. Against a whole nother discussion, kind of what changed, that led to the proliferation of unexamined filings. And then a lot of the problem is a little bit out of sight for the judge. You know, the judge wants to see a big settlement. A big settlement happens. The judge doesn't know or doesn't have any reason to really dig into, well, of all the cases that got dismissed, which is what I was hoping would happen, which ones actually were compensated, which ones were dismissed without any compensation, which ones were voluntarily dismissed once the lawyer had to dig in and look for medical records and things like that. It's all pretty far out of sight in many cases. And again, there's a little bit of, well, it didn't cause me any stress, so is this a big problem? And there were a couple well-respected judges who issued some fairly well-publicized orders. Judge Casey Rogers wrote a journal article coming out of the pelvic mesh litigation especially, and the 3M earplugs litigation, which were both enormous litigations, where the judges expressed very publicly frustration with what was going on with the number of cases that turned out to have nothing going on. And I don't know, but I think that sort of turned the tide a little bit towards taking this seriously, hearing other judges say this was a really big problem and a very big case for me. So that's kind of I think how we got there. The actual Rule 16.1 covers a lot of different areas of MDL procedure and practice. Things like appointing leadership counsel, things about, what do you do about common benefit fees when certain lawyers have worked for the benefit of lots of other plaintiffs who they don't strictly represent. Lots of sort of procedural things that are, if you're deep into that world, are really interesting, and if you're not deep into that world, are really not interesting at all, so I won't focus on those. But it does include a provision related to the sort of, call it the unexamined claims or the unvetted claims problem. And what it says, like most of the rule, on its face is very, very weak. All it says is that the court should schedule an initial status conference, which I can't believe any of you would say, well, that's an interesting idea. Why would I schedule a status conference? That's what judges do. But it says in advance of the initial status conference, the parties have to provide their views on a whole list of topics. And one of those topics is the early exchange of when and how the plaintiffs will exchange information on the factual bases for claims and defenses. And that is way more significant than it kind of sounds. Because in a regular case, single plaintiff, single defendant, someone took a product, was injured, sued the defendant. Everyone learns very quickly what the factual basis for the claims and defenses is. I mean, they may argue, of course, about the significance of the evidence and whether it's really enough to sustain a claim or whatnot. But everyone knows very quickly whether or not this plaintiff actually took the drug that is the subject of the lawsuit, or whether this plaintiff actually suffered a heart attack, if that's the allegation. In an MDL, early on, the parties know that, or amassed know that for a tiny fraction of cases. The others, there's a big unknown. In many cases, the plaintiffs will have served a fact sheet where they sort of say what but essentially it doesn't add much to a complaint. It's someone saying, I took the pill, here was my doctor, they add, here's my address, date of birth, some more information. But they have historically been notoriously unuseful. We just know that for whatever reasons, those fact sheets don't correspond to reality in a significant percentage of cases. So the admonition that the parties have to present their views on this topic on day one is, I think, more significant than people have given it credit for, because that means at the very first meeting with the judge, before anything has been decided, the judge is required to have a conversation with the parties about when and how are we going to get at the factual basis of the claims, of everybody's claims. It doesn't tell the judge has to do anything at all, and it doesn't tell the judge when they have to do anything. And some of us advocated for a much stronger rule on topics like that, but the committee, I think, had good reasons for wanting judges to maintain a lot of flexibility. But it requires us to do this. And it has led to judges beginning to adopt procedures, and I think we'll see more of it, where early case management requires not just the plaintiff providing some self-identifying information. You know, here's my name, my address, my date of birth, here are the doctors who treated me. But actually provide some evidence, because kind of what we know from experience is that if people have to fill out a form, 20 to 40% of them will turn out to give you a form that doesn't correspond to reality. But if you say early on, just show me a pharmacy record that shows that you actually took this particular pill, which is not hard to do. You know, you can go to Walgreens and they'll print it out for you. Show me a medical record, which you have access to, that shows you actually had a heart attack. That very small step eliminates huge numbers of claims. And if we do it at the outset rather than at the end of the case as part of a settlement, the docket gets cleaned up very quickly. So why does this matter to you if you're in state court? One recent phenomenon, well, one is if you have big complicated cases, you know, I think the same case management tools that the federal courts use are relevant. Obviously, they're optional, but they're certainly relevant and worth considering. But two is the recent phenomenon has been in mass torts when litigants are unhappy, well, plaintiffs are unhappy with rulings they get from the federal court, is that the litigation shifts to state courts. Because, you know, being in federal court in a case like this, based on diversity jurisdiction, is largely optional. And if people don't like the procedures they see in federal court, they will opt for what they perceive as a friendlier state court forum. You know, people are entitled to do that, but what I think that means is that state courts, not just in Philadelphia and Los Angeles, but across the country, or Cook County, I should throw in too, are likely to see more and more high-volume mass tort filings.
Thank you, Kaspar. We'll obviously come back later for more discussion, but I do want to touch on just one thing that he mentioned, and that is the new rule. And the language he was referring to, the rule says that the parties must disclose, and it is an initial view, so there's a lot of room for change down the road, but it says the factual basis for their claim. So I think that's something that the judges can sort of hang their head on to push the parties before them to be a little bit more specific than maybe has been the case up until now. Okay, we'll turn to Michael now.
Good afternoon. Till about 5 years ago, I think most of my practice was focused on consumer class action defense. So I'm not in the mass tort world. It was basically defending companies in consumer cases. And then about 5, 6 years ago, this phenomenon of mass arbitration came up. I'm interested to look at the audience. Are people familiar with what mass arbitration is, generally speaking? Okay, let me give you a little bit of background. So what happened was, and this was really pioneered by Warren Postman, who was, I think, chief appellate counsel at the chamber, if I'm not
Something
mistaken.
like that.
He had worked for years with the Chamber of Commerce on defending, helping write briefs, amicus briefs for companies in connection with arbitration agreements. And as many of you know, you probably dealt with motions to compel arbitration. The Supreme Court has spoken often in connection with motions to compel arbitration and arbitration agreements, the enforceability of arbitration agreements, especially with class action waivers. That was a hot topic until 2011, when the Supreme Court, you worked on the case, Concepcion came down and ruled that class action waivers in arbitration agreements were enforceable, and states could not develop rules that thwarted the public policy favoring arbitration. So that sort of changed the dynamics. So a lot of companies, consumer-facing companies that had agreements with individuals, put in arbitration agreements with class action waivers. And for years, companies used that effectively to move class actions out of court and into arbitration. When Concepcion came about, and AT&T was the company that went to the Supreme Court, it developed and AT&T developed a very consumer-friendly arbitration agreement, where basically the consumer pays nothing in connection with an arbitration. The business would be responsible for all arbitration fees in connection with the arbitration. They'd have to pay their lawyer, but all fees associated with arbitration were the company's responsibility. And most arbitration, a lot of businesses had arbitration agreements like that. Under the AAA and JAMS rules, they require the business to pay the bulk of the fees if the agreement were silent. So the consumer would only, or employees actually, would only have to pay a very small portion of the arbitration body's fees. The business would have to pay the bulk of those fees. And that was the general principle, and that is still the general principle for the large arbitration bodies. And the idea behind it is we want the consumers and employees to be able to have their disputes resolved in an inexpensive way. I mean, that's the idea behind it. So Warren Postman saw all of this, saw all of these arbitration agreements over the years, and thought of a very, and I think it is clever, way to try to, I'm going to use a very strong word here, extort companies, in our view. And so what he decided to do was, he said, well, if I could gather a large number of individuals to sign up with me and pursue arbitrations at the same time against the company, I will have significant leverage in connection with a possible resolution of those claims. And so companies all of a sudden were facing 10,000, 25,000, 100,000 claims at one time. And when this first started, the arbitration bodies immediately issued an invoice once these claims were filed and said, okay, business, you owe $20 million today before you even get to the merits of the case. Before you can even vet any of these claims, you must pay this immediately upfront. So that was a dilemma the companies were facing in the beginning, and many early on folded and quickly settled those claims out rather than fighting this. There were some initial court battles where companies tried to say, well, this is the equivalent of class arbitration, which is barred. And the courts basically said, sorry, no, your arbitration agreement, this is not class arbitration, or you take that to the arbitrator. So you pay the fees first, and you can make those arguments in arbitration. Of course, you'd already paid up front, you're not going to get those fees back, so they were stuck, their businesses. Now, the arbitration bodies have modified their rules slightly to alleviate the upfront costs, but the overall costs are still there in connection with mass arbitration. So the name of the game for these plaintiffs' lawyers, gather as many claimants as possible to, have the maximum amount of leverage against a company in connection with their arbitration program. So how do they do that? They do that a couple of ways. One way is through social media campaigns. So you will get an advertisement potentially on social media that says something like, are you a customer of business X? If so, you may be entitled up to $5,000. Take 2 to 3 minutes to fill out this survey, click through, and you're signed up. That's what happens. And so they see this sticker price of $5,000. I could get $5,000 with this. Quickly run through this 2 to 3 minute survey, and bam, they're arbitration claimants. Another way we have seen these lawyers find claimants is in connection with class action settlements. So if a firm gets access to a class list in class action settlements, we have seen some firms recruit those class members where they were class counsel for new claims. Now, query as to whether or not that's permissible under the ethical rules, but we see that happening in some of these mass arbitration gathering. And so if you actually then look at these surveys out there really do not gather sufficient information for the plaintiff's lawyers to properly vet the claimants. So they're asking just basic questions. They're not actually getting into the merits of the claim that they're going to pursue against the company. And they're just saying, relying on whoever this person is, not talking to any of these individuals and saying these individuals have valid claims, and then submit them to AAA, JAMS, or to the business. There has been a lot of coverage and a lot of analysis. We've done this. We have a database of mass arbitration claimants that we have gathered over the years, and there's a lot of overlap, as you can imagine. We see consistently the claimant pool being, I would say, between 20 and 75% defective. That is, they aren't customers of the company. They're dead. If they are customers of the company, they didn't have the issue that's alleged in the theory of liability. And when we bring this to the attention of the plaintiff's lawyers, they have to say, well, just tell me who they are. You do the vetting for me, and I'll drop them. So you can imagine a business that gets this, and they're saying, wait a minute, you just dumped 25,000 claims on me. You want me to do your work for you, spend my limited resources going through all of this, and tell you who can bring claims against my client under a theory I think is not really viable anyway, that I'm gonna have to defend in an arbitration process. And so you see the problem here. The problem is AAA, JAMS, other arbitration bodies, they're not in the business of being gatekeepers as to which claims have merit up front or whether someone's alive even up front. They don't have the resources to do that. And they think of themselves as clerks, essentially, like court clerks, that they don't have the power to do that. Now, both JAMS and AAA have now a process that businesses and plaintiffs' lawyers can go to AAA calls it a process arbitrator. JAMS calls it a procedural arbitrator, where the parties can go to that arbitrator up front before the bulk of the fees are paid and ask for some relief. We have done that a few times and gone to process arbitrators and said, we need some more specificity. We need you to go back, have the plaintiffs' lawyers go back and actually, one, find out if they actually know an arbitration has been filed in their names. Because oftentimes these individuals who are signing have no idea that arbitrations are actually being filed in their names. Oftentimes they actually think they're signing up for class action settlements because the advertisements are so vague. They think that, oh, I can get this money, there must be I might be a class member participating in a class settlement, not realizing that their name is being used in a legal proceeding against a company. And so we have attempted to go to process arbitrators or procedural arbitrators and say, could you ask them to go back and actually do some vetting here and do some work? And in some cases, we've been successful, and we've had process arbitrators order that. And you know what happens in those cases? The claimants' counsel go away. They don't want to do the work. They don't want to actually go through the process. I just read a brief in one of my cases before a process arbitrator where we asked for this information. The response was, if I do this, mass arbitration won't work. Now, is that the business's problem? Because it's not working for you? There was a good case that came out. There was a case that came out where a process arbitrator ordered in a Wells Fargo matter more definite statements, essentially, because Wells Fargo had determined that the claimant pool was really deficient. Many of them weren't Wells Fargo customers. Many of them didn't have the issue involved in the underlying dispute. Process arbitrator ordered more information to be provided. The lawyers in that case went to court and tried to overturn that decision of the process arbitrator. The court, federal court in California and the Ninth Circuit rejected the attempt to overturn that determination, saying that's an intra-arbitration dispute. We're not going to look at that. But the defense lawyers, the companies are really it's up to the process arbitrators to do this vetting. Unlike court, there is no oversight here. That's the problem with mass arbitration. Unless an issue gets to a court and a court actually asks questions and looks into some of these practices, the businesses don't have a lot of opportunity to have these practices looked at. There was a big case that came out, it's a Samsung case, out of the Northern District of Illinois in the Seventh Circuit. In that case, Samsung refused to pay arbitration fees. They thought the claims were frivolous, and ultimately prevailed on that because the claims were brought in court later and the judge dismissed the claims. It was a BIPA claim. But they brought, on behalf of 50,000 people, a motion to compel petition to compel arbitration in federal court. The district court ordered arbitration and ordered Samsung to pay arbitration fees. Now, there was zero evidence that all 50,000 were actually Samsung customers. No evidence of contract formation whatsoever. Second Circuit reversed on those grounds. Second Circuit said, you have to provide evidence of arbitration, each person, in order for arbitration to be compelled. So the Seventh Circuit sort of got the issue that these claims are being advanced without any vetting, but didn't go further and say, you know what, someone should look into these practices. And that's where I think you all are gonna see this. You're gonna see this in motions to compel arbitration where a business decides, I'm not gonna play this game. And then under those circumstances, it might give all of you the opportunity to say, question some of these practices and say, what's going on here? Did you actually vet these folks? Do they actually have arbitration agreements with the company? A lot more to say on this, but I think I'm out of time.
Okay. And we'll definitely come back to you, but let's go ahead and hear from Archis next.
Well, thanks very much. Thanks for the opportunity to speak with you today. I'm Archis Parasharami. I co-lead our firm's class actions and aggregate litigation practice. I say that everybody's heard of class actions, but Kaspar and Mike have talked about two interesting and, frankly, problematic forms of aggregate litigation, mass torts in court and mass arbitrations. The common thread that you've heard, which I see every day, is that there are serious problems with the quality of claims filed in both types of proceedings. The title on the screen, I think, is a little bit academic. It should be academic in a conference like this, but I'm going to offer a renaming of the panel. In big cases, when are claims bogus, and what can we do about that? And I say that, maybe it's a little bit, provocative, but I actually think that the data bear it out. This is a real problem. The examples of, unexamined is probably a more refined version of that, because I think it's fair, because it is like they come in this black box and no one has looked at them. The defense looks at them maybe for the first time. The plaintiffs almost never look at them, which is shocking and disturbing, but true. The examples of these bogus claims abound. I've co-authored some reports addressing both MDLs and mass arbitrations. I think the MDL report's in the materials. And what those reports found and other reports are like this are coming out, that these abuses are common. Kaspar pointed to this, the MDL subcommittee of the Advisory Committee on the Civil Rules, the committee that ultimately developed this new Rule 16.1, estimated that between 20 to 50% of claims filed in MDLs are either marginal or frivolous. That should be disturbing to everyone. Mike has talked about the flood of frivolous claims asserted and threatened mass arbitrations with these numbers, disturbing numbers, 20 to 70%. So I have a case right now, and so maybe this is one of the good ones, which is disturbing, but in this case, our client was able to determine that of the thousands of threatened claims, 20% of the claims were frivolous on their face. What do I mean by that? Some percentage of them, 4% of them, were not customers of this company at all. No records of these people as customers, and the customers couldn't prove it. The remaining 16% had obtained a different product than the one they were bringing claims over. In your courts, I have to think, this would be literally laughed out of court, baby sanctioned. It is the order of the day in mass arbitration, and it's partly because no one looks at them in mass torts till the very end, the order of the day in mass torts litigation. Now, many judges are worried about the problem of questionable claims. You do hear about that a lot in MDLs, maybe not as much as defense lawyers would like, but Kaspar pointed to some examples. I have to say, some courts, unfortunately, have thrown up their hands and said that essentially in cases like these, mass torts cases, aggregated individual claims like mass arbitrations, this is just a fact of life. That's a problem. And it's especially a problem because, and both Mike and Kaspar talked about this, some plaintiffs' lawyers are weaponizing this phenomenon. What they try to do, and this is the common thread between the mass arbitrations and mass torts, and in a different way in class actions, though I think it's, in class actions, you just need the one representative, the claims will come later, so they don't have the same problem of multiple issues, although you will find these named plaintiffs who also have that problem. I'll tell the story. There was an Apple case where the case was headed to trial, and as the trial was proceeding, they learned at trial that the person who was suing had not bought the Apple device they were suing over. That's a real story. And this was the class representative. And bizarrely to me, at least, the court allowed the plaintiff's lawyers, not the plaintiff, because the plaintiff didn't have a claim anymore, to sub in a new plaintiff at trial who could bring the case, because the trial had to continue. Problematic. And I think, at a high level, you talked about this, about the gathering of inventory. It's something that's been going on in mass torts forever. I mean, all you have to do is turn on your TV or listen to the radio, and there's an ad trying to get you to call in or to go online to say, I have an asbestos claim or a pharmaceutical claim or what have you. And the same thing is now happening in mass arbitration. Because I do research on this and am a defense lawyer in these cases, now I get the Instagram ads asking me if I have watched ESPN, and if so, would I like to sign up? And it's always that, sign up for compensation. They don't say sign up to bring a claim against ESPN. They say sign up for compensation, as though the case has already been settled, which I think is also misleading and problematic. So that's kind of the goal here, is mass up the claims without due diligence into whether these claims are valid, and then coerce settlements and say either we're going to be in court with you for the next 10 years and you'll be paying all these attorney's fees. I'm actually getting the good news to lawyers like the three of us, I guess. But I mean, it's bad for the system that's the cudgel that the plaintiffs use. Or in mass arbitration, you will, as you said, you'll face millions of dollars in fees if you don't pony up a settlement. And they use, they use law and economics to say it's irrational for you not to pay us, say, half the fees you would be paying the AAA, which is why all those settlements happened in, let's call it 2018 to 2021, until businesses started pushing back. So, I don't want to repeat what folks have said, so I'm going to try and keep this a little bit tighter. I'm just going to offer two ways in which we can suggest pushing back against this problematic phenomenon. It doesn't have to be this way. First, with respect to MDLs and mass torts in state court, the Federal Rule of Civil Procedure 16.1 that Kaspar mentioned, which is, I think it's, in a sense, it's advisory in federal court. It's binding, but it says should in most places. And certainly it's, just a piece of advice to consider in state court. But, it actually, if you were to take it seriously, it offers a good framework for early case management. The best line in it is that it requires parties to propose, quote, how and when the parties will exchange information about the factual bases for their claims and defenses. Judge Alvarez pointed that out as well. And while the rule speaks in terms of should, not must, and maybe the best defense I can have for that is that, that judges should be entitled to discretion, which I think, essentially our system does call for, so judges can manage each case in particular. But I would encourage courts to exercise that discretion in favor of turning the shoulds, at least for the parties, into more of a must. One thing courts should insist upon in mass torts cases is that plaintiffs' counsel provide basic verifying information about their client's claims very early on. The lawyer should have to demonstrate that their claimants used the product at issue and suffered an injury. That isn't some massive undertaking. That is what Rule 11 and the state law equivalents require. That's what the rules of ethics require. Rule 3.1 of the model rules requires that lawyers undertake a reasonable investigation. I'll submit, hopefully this is not a controversial statement, that if you are a lawyer who brings a claim against the company, that your client should have used the company's product or service. That, like, if that's controversial, but like what is amazing is that actually it is controversial what the plaintiffs are. I think they would push back. I regret that we don't have someone here who would tell us like why that's wrong. Although again, I do think it's really problematic that they can't say that, but they actually can't say that. And I mean, that's what the data shows, that you know, this isn't my data. This is the MDL subcommittee of the Advisory Committee on Civil Rules, a pretty significant organization, looks at this and says 20 to 50% of the claims are not real. So that's one thing that I would encourage for courts in the context of mass torts. And then in the context of mass arbitrations, and I know we'll talk about this, what companies have done after initially, you know, frankly, having to surrender or face these massive fees was that they revised their arbitration provisions to put in some, I would call it, whether it's speed bumps or breathing space, moments for the parties to connect and exchange information, not unlike what's contemplated in 16.1, where there can be some assurances before the arbitration fees kick in that the claims really have at least some indicia of merit. Not is the claim, you know, right or wrong on the law, but did you purchase the product or service? Did you do it within the statute of limitations? Just the 2 or 3 kinds of basic questions that appear on forms. This has become very commonplace. Some courts have approved these kinds of arbitration clauses. Many have. Others have not. Others say that this imposes enormous delay. I have a question about whether that makes sense given what, and maybe Kaspar can speak to this, what the average time for a mass torts case in court is. Like, the idea that, say, 10 or 20,000 mass torts plaintiffs are all going to have a trial, that would overwhelm your courts. That would be a disaster. That's not how it's done in court. That's not how it should be done in arbitration. So I think that some openness to those kinds of innovations would be a good thing. And then I guess the last thing, and this is maybe a little more loose, I would say, a little more aspirational, is just to say that I think judicial expectations matter. I think most lawyers want to keep judges happy. I try to keep judges happy in my job. I think I'd be a bad advocate if I didn't at least have that as a goal. It would make a world of difference if judges communicated to plaintiffs' lawyers that the way to keep judges happy is to present a clean inventory of cases, and that a good way to make a judge unhappy is to provide a less than clean inventory of cases, a ton of meritless claims. Now, I have to say, unfortunately, that hasn't historically been the norm in MDLs and much mass torts litigation. And it certainly hasn't been the norm, at least early on, when courts have confronted the problems, the abuses of mass arbitration. We've seen some notable counterexamples in the 7th and 9th Circuit, including the case that Mike mentioned. But it cannot be the case. I mean, I think this is not just aspirational. I think this is actually descriptive. It can't be the case that judges want to see the legal system inundated with meritless claims. I think that is not what, you can tell us when you wake up in the morning, that's not what you want to see. That's not why you go to work. You want to make a difference, right? And I think that this is the thing I would leave with, at least in this introductory set of comments, that making this point, which I think is implicit, making that express would be a huge step in the right direction.
Thank you, Archis. I have to disagree with one thing. I really do think that lawyers wake up in the morning trying to figure out a way to irritate me. So
Well,
I have a question for the audience before we move on to the discussion amongst us, and that is, how many judges here have, whether it's federal or state, handled MDL or mass tort kind of cases? Okay, so it's a fair number of you. I was surprised, and Archis has an article that I read in preparation, and you should have read for this conference. But that in the federal court system, about 2/3 of our cases are MDL cases. So I was really surprised at that figure. Personally, I have not had MDL cases assigned to me. I've had my cases go to an MDL judge for pretrial matters. When they've come back to me, for the most part, they've all been resolved one way or the other. But I do think that this is something that we all should be very aware of, because I do think that these cases are going to continue to rise. We've heard it throughout the day on the various topics that were covered, that all of those topics, mass tort litigation, MDL, maybe there was not a lot of reference to mass arbitration, but I think some of the very issues that are impacting the courts in the mass litigation also come into play when you're dealing with mass arbitration. So I know as a judge, the one thing I do not want is cases without merit, whether they are frivolous cases, and obviously we have a legal definition of a frivolous claim, whether they are unexamined cases, whether they are fraudulent cases. We don't want to have to deal with those cases. So I understand the concerns that the panel has raised about trying to deal with those early, but I also know as a judge that I do not want to have to repeat the process twice. And I know that from my perspective, one of the concerns would be in trying to weed out these cases earlier would be, well, am I going to have many trials up front dealing with these cases and then have to repeat that process for those that move forward? I think that in some regard, from the plaintiff's perspective, as I mentioned earlier about in the federal court system, criminal defendants routinely file habeas claims once they've completed all of the appellate process because it costs them absolutely nothing to do so. I think we may be seeing some of that from the plaintiff's perspective with some of these cases. I would like to hear from the panel, one, any response to any of the comments from your colleagues here, but also any thoughts that you have about how we can address the issue, the concerns that you've raised, but at the same time, not have a judge push back because I don't want to have to do this twice.
Yeah, no, that's in the discussions leading up to Rule 16.1, a frequent comment from judges more than litigants was, if there are 10,000 cases, like what can I possibly do to evaluate these case by case? Which is, in some sense, a broader criticism of mass torts that cases don't get individual attention, but that's is what it is. And I think the answer is that's a very important concern, but it is much easier to deal with than I think people think, because it just none of this is magic. A lot of this gets done at the end of cases successfully, and can be done much more easily at the beginning of the case. So, a very simple example, and there's everything's got to be tailored to the right case. But if the claim is that claim is that you have a heart attack from taking a pill, and you can adjust this for it's a car with an emissions defect issue or whatever the situation is, exposure to drinking water that's been contaminated. Within 60, 90 days, whatever it is, of filing your complaint, you have to submit a fact sheet that will give some basic biographical information that will allow the defendants to collect your medical records. You probably need a HIPAA waiver. But you will also provide documentary evidence that you took the medication and have the diagnosis, or explain why you cannot. Hypothetically, if all 10,000 people came back with long, convoluted explanations, and the defendant looked at that and said, I don't buy it, that makes no sense to me. Yes, hypothetically, the court would then be stuck with 10,000 disputes. As a practical matter, that has never happened and never will. We know that from experience. And if that starts to happen, of course, the judge can change the process. The judge can say, we tried this, it's a disaster, I'm not doing it anymore. But our experience is when something like that happens at the end of a case, when you need it to participate in a settlement, the people who are able to do it very quickly because they want to get paid. And the people who are not able to do it, 99% of them voluntarily dismiss and disappear. And you've got a tiny number where you actually have to resolve a dispute about whether there's sufficient evidence that they really took the pill. So that's, I think that's a legitimate concern, but it is not as difficult to come up with ways to address it than judges sometimes fear, or parties who are opposed to this persuade judges that they should be scared of.
I'll just offer up. I feel like my reaction to that is that an ounce of prevention is worth a pound of cure. And what do I mean by that? That the kinds of questions that Kaspar asked, if a court were to say, I'll take a hypothetical case involving cars. Somebody sues over, we'll take the Ford Focus from 2021. It's easy for, in a mass torts type case, for the plaintiffs to put that in a complaint and really not think about it because they got something from online, like some online ad. But what if all that was required was put in an affidavit or put in a document with the names of the plaintiffs and their VIN number? The VIN number is, every car has its own VIN number. It's very easy to find if you're the owner of a car or if you've ever bought or leased a car. And then, submit that. Now, I'll tell you what will happen is if that there are a lot of bogus claims, the people who can't come up with those VIN numbers, they're going to start dropping their cases. And so instead of the problem of doing 10,000 cases twice, it might be more like 2,500 or 5,000 drop out. And so that I think ultimately saves courts a lot of time.
Let me just add, I think there also has to be more accountability for lawyers. I mean, lawyers have professional obligations with vetting claims and not bringing frivolous claims. And the courts are empowered. They're the first gatekeepers. I know bar associations also, have that responsibility, but the courts are the first gatekeepers. Earlier this year, the Florida Bar had a case against, it was an individual about violating the ethical rules. It was a tobacco litigation. And the lawyer was accused of submitting thousands of bogus claims, including on behalf of deceased people and individuals who had never, who were time barred, who hadn't actually used the product. The argument on the other side, and we see this all the time in mass arbitration, is like, how am I supposed to do this if I'm representing thousands of people? And the court said, sorry, that is not an excuse. He said, I'm reading this, the lawyer argued that his conduct should be considered in the context of the thousands of cases at issue in the time constraints imposed on him. And the court said, but the existence of these factors do not alter or diminish the professional responsibilities of the lawyer. The lawyer is required under the rules to handle all the cases with the same standard of care that he would provide to a single case. That's the rule. And oftentimes it gets overlooked. And I think if there was more enforcement, if there was more publicity about this, about bad acts, because look, I'm not trying to paint all of plaintiffs' lawyers with the same broad brush. There are some that actually do vetting. And some in the mass arbitration space are better than others about vetting. We see that. But when people are blatantly violating their ethical obligation, it hurts the court system, it hurts the lawyers, both those sets of lawyers, and it hurts the arbitration bodies, and which are overwhelmed with this, just like the courts are overwhelmed with this.
Agreed.
So actually, I agree with what Mike just said, and I will point out that Rule 11 does not have an exception for if you're handling too many claims to give personal attention to each particular claim, you can just follow them and worry about it later. So I think Rule 11 is already in place and already gives us a mechanism for enforcement here. But I think at least, and again, I've not had MDLs, but I've had cases that are multi-plaintiff cases, and so this comes up in that regard too. But I think a lot of times lawyers are just figuring, like, let me bring everything I can and then sort out what will stick. So trying to resolve some of these issues early on, I think Rule 16 gives us at least a little start, but I don't know, and I read through all of it because I really had not familiarized myself with the rule before I was asked to moderate this panel. But I don't know that it necessarily gives us a really strong mechanism for dealing with some of these issues. So I would ask any one of the panel members, your suggestions for how we can better address these issues.
Yeah, so it absolutely, and very deliberately, I think, does not provide a mechanism. I think the committee was very concerned with the sort of one-size-doesn't-fit-all problem. And obviously, like what I just described for a pharmaceutical case probably wouldn't work well simply for an over-the-counter drug where people don't have prescription records. So, absolutely, the procedure's not written in stone. What changes, the one mandatory change is that the judge needs to talk about this with the parties on day one, and the committee is telling the judges, this is a real problem you should be thinking about. That, is a step forward. But I think the way I would approach it as a judge is to say, to the lawyers, it's back to my, asking the managers how many innings we should play a little bit. But, you know more about this. Forget about more about MDLs, but you know more about this case than I do, obviously. What are going to be as you see it today, the sort of gatekeeping issues, the gates that are likely to tell you whether a case is a serious case or a not serious case, one that probably shouldn't have been filed. And that may differ, obviously that could differ enormously, but that allows you to say, and then you can look at it and say, well, for your gate 3, I get your point, but that requires 2 years of discovery, so we're not doing that on day 1. But your first 2 gates, or however you want to describe them, absolutely makes sense. You know, did you own a car? Did you live in the state of California when you had the car, or whatever the issue is? And you know, I think it's important for the judge, I mean, one, to ask the parties because they do know the case, but it's also really important for the judge not to defer to the parties on what to do because, again, you're talking to advocates. They both represent, everyone represents a client. And everyone is trying to figure out what will be best for their clients in the long run, which is what they're supposed to do. That's the adversary system. But it is really dangerous, and I think it's frustrating when judges become too differential to lawyers on topics like that. Sort of on the theory, like you guys know what's going on, I don't. Well, you're neutral and they're not.
One thing you said, but this is just a brainstorm, maybe it's controversial, but you know that on the plaintiff side in mass torts cases, there's always a debate about who is going to be the leader, right? Who's in the leadership structure. What if, just like sometimes courts hold competitions to see who can be more efficient with respect to fees, what if courts ask those who are vying for leadership positions to come forward with a plan for reducing the problem of unexamined claims? If that was part of the mix, I could imagine the lawyers on that side who don't currently have incentives to be great at that, doing a lot better.
And I do think the rule will at least give judges that have not dealt with this before a good place to start. And again, you know, the federal rules obviously don't control the state courts, but I know state courts are dealing with the same issues. And if you don't have particular rules to deal with these kind of cases, then you know it might be good to have this as a reference. So, I have a question for Mike along the lines of the same topic, and that is you talked about in arbitration now having a process arbitrator. And in that regard, is it something that is written into the arbitration agreements now? And is it mandatory? Is it something that basically you have to get agreement between the parties? Is one part of my question. And then the other part of the question is that I think, right or wrong, historically, arbitration was seen as favoring a defendant, and often it was defendants pursuing enforcement of the arbitration agreement. Do you think that that's going to shift some based on some of these problems that you've raised?
Let me hit the second point first. I think arbitration favoring defendant, yes, in the sense that you're not facing this class action risk, which could be existential for a company. And it could just be the mere risk of class action sometimes causes companies to settle what probably they could win because they just don't want to go through the risk associated with that. But if you actually look at arbitration decisions, consumers actually do better by and large in arbitration than they would in the class context. They get larger amounts in awards if they have meritorious claims than they would have participated in the class action. And you've done a lot of research on that point, and you can add anything. So, that on that point. As to the process arbitration, I'll speak to AAA. So AAA adopted a rule that says if you're in a mass arbitration, they have supplementary mass arbitration rules will apply if the claims are filed after a certain date. And now any claims that are filed now would have the ability to have the mass arbitration rules apply. And as part of that, there's a possibility of having a process arbitrator. What that means is the process arbitrator can determine administrative issues that the AAA sends to the process arbitrator. It can be by agreement of the parties, but the parties could also disagree as to what can go to a process arbitrator, and the process arbitrator has the right to determine his or her own jurisdiction over those issues. So by and large with the AAA, it doesn't have to be by consent of both parties for issues to be presented to a process arbitrator for determination. But again, it's up to the process arbitrator to sort of sort all of this out and decide, what issues they can address or not address.
And then would the appellate process for that be the same as a regular arbitration? Or?
So the way the AAA rules have the current AAA rules, the parties have the ability to have a merits arbitrator look at a process arbitrator decision, I believe it's for abuse of discretion of that, because it's supposed to be purely administrative, nothing on the merits.
Was there something you wanted to add on?
Well, I'll just tack on, and this is to the point, Judge, that you made, that that often arbitration agreements also will expressly delineate what a process arbitrator is supposed to do. But in the absence of a specific provision, then what Mike said is 100% how it works.
Yeah.
All right. Okay, we're in the Q&A process. I do see that we have somebody ready with a question there, so we'll turn to.
Would another alternative to the problem of mass arbitrations be simply for big business not to require arbitration every time you buy a phone or download an app and it's buried in the fine print and you know 90% of the people aren't going to read it and those that do aren't going to understand it? And arbitration is to keep the courts out of the business, and now you want the courts to get in, but just with their toes to help you guys out. And so I'm not feeling too sympathetic, but.
That is a fair question, and a lot of businesses are considering that. Include the most prominent business to decide to remove arbitration from their agreement was Amazon. Amazon was faced with mass arbitration, it was killing them, the mass arbitration, and they said no mas, and they removed the arbitration agreement. Apple doesn't have an arbitration agreement in its consumer contracts. There are businesses that make that choice. Now, when Amazon removed the arbitration agreement from its consumer agreement, there was a significant uptick in class action filings against Amazon. So you're balancing, right? As a company, you're trying to think like, what's the best way to achieve resolution? Now, a lot of companies have in their consumer agreements pre-dispute resolution procedures. So pre-arbitration, pre-litigation procedures where they invite consumers to come to the company to try to resolve their issues. For clients that we represent, that's very successful. They're able to solve a lot of these problems up front, short of litigation or short of arbitration. And from our clients' perspective, they think that's very successful and keeps the consumers very happy, that process. So.
I'll just offer up, I think it's a fair question. I think that the reason that arbitration increased meaningfully in popularity after the Supreme Court's decision in Concepcion was because at least businesses believe, and I think not without cause, that there were serious abuses of the class action process that led to problems with essentially forced settlements based on the filings of class actions, largely without regard to merit. And so I think businesses looked for an alternative that was fair to consumers and to workers. And I think, to your point, the data does show that individual consumers and workers do better in arbitration than they do in court, but at the same time reduce the cost of litigating class actions. And we've done studies where, I think it's fair to say, I don't think this will come as a surprise to most people. The real winners in class action litigation tend to be the lawyers like us who defend them, and lawyers on the plaintiff side who bring them. But it is rare that the winners in class actions are actual people who I think, for most folks in this room, are the people that you care about.
I will say on that front, I think a positive development, especially in California, is more scrutiny over the attorney's fee awards in connection with class settlements. That is a good development for consumers, businesses alike, I think. So.
Agreed.
Okay. Next question.
Yes, 2 points. Number one, I've seen arbitration clauses which contain a provision that the consumer will not bring a class action in arbitration, but that doesn't solve the problem of mass arbitrations. But it's a good step. And as you were speaking, I was just trying to make a laundry list of things that could be done to put more heat on plaintiffs' counsel not to bring frivolous claims, because I think we all agree, whether it's under Rule 11 or the rules of professional responsibility, unfounded claims should not be brought. And, my questions are, can some of these things be done? Number one, can Rule 11 be applied to arbitrations? It's not part of a court proceeding. Number two, what about the rules of professional responsibility? What does that say about it? Number three, and these are some of the things I wrote down, who pays the filing fee for the arbitration, and can that be increased? And to put some heat on the plaintiff's counsel not to bring frivolous claims, and also rules like if you lose, no fee is paid. Not that the company will automatically pay the fee. Also, if you file the claim, you got to attach some proof, not just fill out a form that says, yes, I bought the prescription at such and such a pharmacy. So I was wondering whether or not any of these things are being pursued by defense counsel or companies.
So one of the things that we have advised clients to do in updating their arbitration agreements is to put in a provision that Rule 11 would apply. The arbitrator has authority, equivalent to a court having authority on, to sanction attorneys in connection with bringing frivolous claims. Now, let's pause. Is that enforceable? I mean, the attorneys aren't parties to this contract. The consumers are parties to the contract. So it remains to be seen how an arbitrator is going to rule on that. I haven't seen an arbitrator rule on such a provision and sanction a lawyer in arbitration. I think most arbitrators believe they don't have that authority. I've heard that from arbitrators before. Yes, the arbitration rules themselves, and in arbitration agreements, you can have fee shifting. You can have, the AAA, for example, has a rule that says if claims are brought for an improper purpose or are frivolous, then the fees can be allocated, that the arbitration fees, not attorney fees, not, you're not going to shift the attorney fees, but the fees of arbitration can be awarded to the prevailing party. That doesn't really help, though, as to the lawyer. So the consumer's the one, or the employee's the one, that most likely is going to be on the receiving end of such bad conduct. And that's because there's no teeth there, and there's no, if the arbitrator believes that the arbitrator doesn't have authority to enforce sanctions or to award sanctions against an attorney, they're not going to do it. Now, the Bar Association can. You can bring a bar complaint. A company can bring a bar complaint. A lawyer has an ethical obligation to bring a bar complaint if he or she believes that your opponent has committed an ethical violation. Our whole system is based on, self-reporting, it's self-policing and all of that. It's just not done. It's just, we don't see a lot of that happening.
I'll just, an idea that I really liked that you mentioned that I think some companies have started doing is, as part of a pre-arbitration dispute resolution process, calling for basic identifying information to be provided in connection with that. And that, I think, when done properly and enforced by courts, really can reduce the degree of fraud that's going on.
Well, in the federal court, I guess in the state courts too, if you bring a frivolous claim, it can lead to sanctions. A judge has a right to refer a matter to the disciplinary boards. Perhaps rules can be changed.
Yeah. The arbitration body should make it clear that the arbitrators have this authority, and they haven't. AAA recently amended its consumer rules and asked for comment from the bar, those that practice before AAA. And we were part of comments that suggested that they should make this clear, that arbitrators do have this authority to sanction lawyers, and they didn't make that change.
I wonder if it could be written into the arbitration agreement that you or any agent that represents you is bound by this, and that therefore that employee, plaintiff, whatever, maybe has to disclose that to their attorney, and,
well, we have
and the
that.
attorney, and the
So-
attorney knows he's bound by that.
That is in some of the arbitration agreements that we defend. If you're an attorney and you're bringing the claim, you say, I'm not a party to that contract.
But you're
My
an agent.
client is.
Yeah, but you're the agent for the client.
I'm with Judge Alvarez. I'm on this agency theory.
But the most frivolous claims are the ones where somebody never actually used the service, and so
Yeah.
they never
Right.
agreed to
And
anything.
they're not
Well,
bound by arbitration,
Yeah, that's
right?
a great point. That's a great point.
I don't see any other questions. We still have a little bit of time, so I'll ask a question in this regard. So I I am a firm believer in Rule 11, and I think I'm probably one of the strictest judges about holding lawyers accountable for their actions in front of me. And I have on more than one occasion, used Rule 11. I am often amazed that the lawyers, the opponents in front of me, don't really pursue Rule 11 sanctions. That often I'm sort of the one raising the issue, and if I raise it on my own, then I'm maybe a little bit more hesitant to move forward with it. But if the lawyers raise it for me, I take a stronger position. So my question to each one of you is, do you find in this arena that defense lawyers, or plaintiffs lawyers for that matter, if they think defense lawyers have violated Rule 11, do you find that the lawyers are pushing the courts to, and if not, why not?
Because I think you may be a bit of an exception in your sort of receptiveness to Rule 11 motions, at least in federal courts. I think, many judges are very suspicious of anyone's motives in asking for sanctions and are extraordinarily reluctant to grant a request for sanctions unless it's something that happened, in the courtroom. If somebody did something during trial that was truly outrageous that the judge sees as, an attack on the process, that's different. But something like this, where you're saying, there are some lawyers who've never appeared in front of you. They're not leadership counsel. They've never appeared in front of you. They're, somewhere far away, just a bunch of names on paper. They filed a lot of cases, that turned out that they then voluntarily dismissed. We can't prove to you. We know that they didn't come up with the evidence, and we know they voluntarily dismissed the case. They could get up here and, we don't know what they're going to say. Judges see that as, I don't know how they see it, but I know there's a lot of hostility you get back sometimes. And it is not doing your client any favors to have the judge suspect that you are playing games with a motion for sanctions. And clients may not be happy about it because they don't really see what good it's going to do them. Because it's not true, but most clients, most defendants don't believe they are repeat players in these cases, even though they definitely are. They think, we just got to get through this big mess. That is our priority. Our priority is not taking one for the team so that other defendants in the future will be better situated, or even us in the future will be better situated. So if you tell them, it's not really going to make a big difference in this case, it might help in your next case, or it might help in your competitor's case. But the judge might get really mad at us too. That's not a great value
I wonder if we
proposition.
could ask an audience question for those of you who are judges. Have you ever issued Rule 11 sanctions or similar? I saw some hands, but it's not like it's happening.
Let's see hands. Let's see hands.
Oh, okay, well, there's
Well, how many have done it like more than 3 times?
wow. Okay.
Okay. Because I was in front of a very
So, but
senior
this is-
federal
but-
judge who said I have never once.
But you
in
know what?
30
This is
years
encouraging because it's a good.
Well, I will tell you one thing in that regard, and that is, it is hard for me as a judge if I'm the one raising it, because unless it happened in front of me, I don't have the evidence to back it up, and that's why I asked whether lawyers were willing to bring it. So if you tell me this case where these lawyers, filed and then dismissed, if it's a one instance, I might say, I'm not gonna mess with it. But if you say, Judge, these lawyers have done this in multiple litigations across the nation, it's a consistent problem from this particular group of lawyers, I might be willing to hear it. But then you would have to present to me that.
And I would
evidence.
have to know you well enough to know that I think you will be
I'll tell you that.
receptive versus a different judge who might not be.
Look, that would be my concern, that the judge would think this is a litigation tactic. And, absent like some clear evidence that is just, that you feel like compelled to do it, I would not do it. Now, I was just on a conference with a judge on a Southern District of New York where you have to send in a letter before you file a motion to dismiss. And the judge asked us to file a Rule 11 motion. That's the first time this happened to me. So,
Any closing, maybe 30 seconds, any closing comment from any one of you?
I'll just say, sort of to circle back to what I said before, that courts really do set the tone for this, and the courts that are less tolerant of bogus claims are less likely to see bogus claims.
Well, Thank you very much,
Thank you.
each one of you. It's good to have a very active panel at the end of the day. Thank you.